Now, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Wanted to talk today about hello Goldie, hello Maestro, hello Let Me Reflect, hello Mo. Hello kitties. Thanks for joining me. I wanted to talk about what is the real conspiracy in Karen Reed's case. Now, Karen Reed's defense has been that she is the victim of a real and true conspiracy against her. She's been framed. Her lawyer, David Yannetti, in court, argued in his opening statement, my client has been framed. They presented her to the public as an innocent woman, the victim of a police cover-up. Why they'd want to frame the adjunct college professor and the financier, I don't know, financial expert, I don't know, but that's never been explained. It's all a big police cover-up. We all know who did it until we don't know who did it. But I think what's the real conspiracy that's going on in front of everyone's eyes is what's been happening in the courtroom, in the filings, in the sidebars, to quote the judge, Cannoni, is a flagrant disregard for the laws of our country and the laws of their profession and the laws of our country. And that's the real conspiracy that no one's reporting on in this case. When I say no one, is the real essence of innocence fraud, is the corruption of our laws and the flagrant disregard for the laws of our land. And that's being done by the defense lawyers in this case, while accusing the Commonwealth and the judge of intense corruption. And this is something that is a pattern in innocence fraud cases, where the defendant, the defense, the lawyers accuse the investigators, the police, the Commonwealth of doing the things that they're doing themselves. So I wanted to take another look today at the hearing and show you exactly what I'm talking about and how I believe Judge Cannoni, in my view, is letting this go on, and by letting it happen, she's making it happen. She's becoming a co-conspirator with Karen Reed's innocence fraud campaign, to the intense frustration of Hank Brennan, and I would assume Adam Lally and Laura McLaughlin, but they haven't spoken. We just see Hank Brennan speaking at these hearings, so I can only speak on his reaction. But certainly the last hearing is the first time Hank Brennan had ever mentioned the word fraud, and we'll examine it. But before we do some Karen Reed news, Michael Proctor has been fired, relieved of his duties. Let me just go over that very quickly. And this comes on the back of his wife's interview. I don't know if you saw it. I didn't find it particularly helpful. She used her children. She said, our children don't know that their parents' lives are falling apart. And they talked about the harassment and the undue reverberations of Karen Reed's targeted harassment campaign and innocence fraud campaign. But here it is. Trooper Proctor, lead investigator in Karen Reed's case, has been fired. Massachusetts State Police announced, this is Boston 10, Wednesday morning, that Trooper Michael Proctor has been fired and should be dishonorably discharged. They said their trial board, now this was all done in secret, found Proctor guilty of 3 charges of unsatisfactory performance and 1 charge of alcoholic beverage. The decision came following 3 days of closed hearings that started in January. As the lead investigator in the Karen Reed murder case, Proctor faced allegations of misconduct and criticism for his highly offensive text messages about Reed that were read aloud in court during her trial. He admitted on the stand that those messages were unprofessional and regrettable. So unprofessional and regrettable, but not criminal, certainly. But they do go beyond the grounds of his profession. Had he used and had been more criminally minded, had he used his work phone to call Karen Reed, they would have never gotten hold of his personal phone with his personal messages. State police said the unsatisfactory performance charges from derogatory, defamatory, disparaging. So he defamed a murder defendant. I mean, can you defame a murder defendant? Maybe. Disparaging and otherwise inappropriate text messages about a suspect. Well, now she's a defendant. In connection with the Reed case, i.e. Karen Reed herself, who said she wasn't personally bothered by these messages. If you saw the TV show last night, she says that she was more bothered, it seemed, by reading her messages being read out loud about between her and Higgins, but okay. And or confidential. Okay. The trial board also found that he provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps in the investigation to non-law enforcement personnel, and failed to conform to work standards by creating an image that he was biased in his dealings with the Reed case. The alcoholic beverage charge stemmed from an incident on July 19, 2022, when the trial board said he consumed alcohol while eating dinner on duty, after which he proceeded to operate his department-issued cruiser. Trooper Proctor, so here is the decision. Trooper Proctor, on various dates between January 29th, 2022 and August 17th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a suspect in the investigation to and other individuals. So, and This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps in the investigation to non-law enforcement personnel. This action is in direct violation of Article 582. This is a Class A violation. Trooper Proctor, through his actions on various dates between January 29, 2022 and August 17, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned, as the lead investigator, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect and or otherwise himself, and through the Massachusetts State Police into disrepute. This is in direct violation of Article 582, Class A violation. And it's a Class B violation, lesser violation, I would assume, to consume an alcoholic beverage and then operate his department police cruiser. So that is that. Another casualty of Karen Reed case, because I don't feel he is essentially a dirty cop or a bad cop. I think he showed poor judgment here. I think everyone would agree, including himself. And just so curious, my position on this has changed a little bit in that, he's still text messaging during the trial to the prosecution. You would think he would learn not to put his feelings into text messages about this case or about his work. I haven't talked to him. I don't know, but there certainly was no campaign. No one speaking up for Proctor or any campaign to save his job or help his family. They're really all out on their own. And in contrast to what we're going to look at today, as far as Karen Reed's hearing, it seems small, but let's take a look at it.
Is a decision on the Commonwealth's motion to exclude.
So this is about the ARCA witnesses. If you haven't been following along, Karen Reed told the public, told the court in sidebars, in motions, in hearings, public hearings, presented their ARCA witnesses, which were witnesses that looked at the very limited view. They were determined. They had to determine whether the damage to Karen Reed's car could have been done by reversing into John O'Keefe. And they were given material entirely handpicked by the defense as part of the federal investigation started by Karen Reed and her lawyer, David Yannetti. So they went to the feds and started this federal investigation looking for corruption. It's now closed. They found no corruption. Ditto Michael Proctor. They found bad judgment and poor behavior and bad judgment, but no real corruption, planning of evidence, covering up of a crime, or any of the things that Karen Reed has alleged in this case. So up to when they handed over discovery in early early to mid-February. I hope I have my dates right. Correct me if I'm wrong. They had been saying that these ARCA witnesses were not biased, that they were hired by the federal investigation, and the conclusion that they came to, shockingly, that this damage could not have been done to Karen Reed's car by hitting John O'Keefe, was that they concluded that they were paid for by the feds and that they could have been used by the Commonwealth. That's the way the defense, and it was dropped that in fact they really were only part, it looks like, by the amount publicly that they were paid, it looks like the large majority of the work they did was for the defense. They were retained by the defense. They were paid for by the defense. They worked and molded their testimony to the defenses with Karen Reed's defense lawyers. It could not have been less of a non-biased, neutral investigation. They were hired guns for the defense. And had they told the public that, Karen Reed would have gotten much less support. They had to know that. So here is the hearing where the judge is, when it came out, when Hank Brennan dropped the bomb, when he finally got discovery, and this has been the defense pattern of behavior with the defense team, that they hide all their discovery. And in this case, we had voir dires of the ARCA witnesses before trial. That was completely useless to the Commonwealth. They didn't know what to ask, and it wasn't very forthcoming with information. So they do that on purpose. So they're hiding their own discovery on purpose, I believe, to sandbag the Commonwealth. And still to this day, Hank Brennan is still complaining about not receiving discovery from the defense. So all that's really important. So Hank Brennan drops that not only were ARCA paid $23,925, they were retained, hired, colluded. The defense lawyers, Karen Reed's defense lawyers, crafted their testimony. They could not have lied to the judge and the public more, but here where it's really important is lying to the court. And they lied over and over again. Even after Hank Brennan dropped the bomb, they lie in a motion, and Judge Cannone brings that up. So let's take a look. So here's the hearing where Judge Cannone is going to decide on sanctions. So they could be, my understanding is they could be disbarred, they could be thrown off the case. I mean, this is a major no-no for lawyers to get caught lying to the court. Let's take a look at it.
Employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record.
So these are, she calls them lack of candor, misrepresentations, but let's call them what they are. Lies. They lied to the court over and over and over and over again to win. That's why they were lying, so they could win their case. Because, so everybody who says that, Alan Jackson and David Unetti are such great lawyers, if they are such great lawyers, why can't they win their case by lawyering? Why do they have to cheat to win? I mean, it's really like saying Armstrong was the greatest cyclist of all time. Certainly well paid, certainly famous, but actual skill without cheating? I don't know.
The record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt.
So when you accuse another lawyer of not acting in good faith, you're accusing them of being shady. This is the defense's own words. Now she's reading the defense motion from I believe it's the 25th or 26th of February. This is after it's dropped, all these communications between ARCA, the payment of ARCA, they're still accusing the Commonwealth of doing the things that they're doing. They're saying you're only trying to exclude these witnesses because you're trying to get neutral, unbiased witnesses from the jury's ears, Let me reflect. Thank you so much for the super sticker. I appreciate your support.
To keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page.
Right? Did everybody get that? This is not done in good faith. The reason you want to exclude these ARCA witnesses is not because they're not neutral witnesses. It's not because we've lied to the court about their neutrality and how we hired them in our communications with them and hid our communications in our payment from the court, especially the Commonwealth and the judge. I mean, the Commonwealth and the judge and the public and the jury. Let's not forget the first jury. Had Karen Reed been acquitted, and this came out after she was acquitted, there would be no remedy for it. Karen Reed, you couldn't try her again, even though she was tried fraudulently. She was acquitted fraudulently. There's no remedy for that. And they know that.
Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here,
and there's a very curious point that Hank Brennan makes about the release of the ARCA discovery. Hank Brennan says this is the only discovery he's gotten in this case is the ARCA discovery. And they just released the defense a huge witness list today. They did the same thing last time, and they called very few people. So I don't know what if this is a similar game plan that they said that they would have weeks and weeks of testimony for the defense, and they had days. That's how it went last time. But I am curious with the ARCA witnesses. A curious part in Hank Brennan's filing about ARCA is he got this discovery just as there was a change in guard at the U.S. Attorney's Office. So the office that started this federal investigation had a change in staff, and that's when he got the discovery. And initially in court, he said he got this discovery from the feds. So he connected it to the feds when the defense says, oh no, we handed it over. So you have to ask yourself, a rational person has to ask, was there an agreement between the feds and the defense to not release the discovery until they had resigned from their positions? And it is still unknown, and this is the way Hank Brennan wrote about it, or the Commonwealth wrote about it in their filing. It's still unknown the relationship between Karen Read and the federal investigation. That's the big mystery. And in the old days, I would think there would be some gumshoe detective pacing, hitting the pavement and trying to get an answer as to what the relationship between Karen Read and the federal investigation was. Why was it started? It's not so it's, Karen Read and her lawyers have a lot of gall. So it doesn't surprise me that they went to the feds. What surprises me is that the feds took them up on this investigation. What did they tell them? And why was it started? Was it started because of personal relationships? Were there promises offered? How dirty does it get? Again, some of the hidden conspiracies in this case that no one's really talking about and no one can get to the bottom of.
The defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Read at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Read before I figure out exactly what I'm going to do here.
So that's a interesting part. Models for lawyer disciplinary enforcement. This is the American Bar Association. Misconduct shall be the grounds for one of the following sanctions: disbarment, suspension by the court for an appropriate fixed period of time. So you can get disbarred, you can get suspended. She could have taken away there's 3 of Karen Read's lawyers are working under David Yanetti's Massachusetts license to practice law: Alan Jackson, Elizabeth Little, and Robert Alessi. She could have taken away her lawyers, but that would have, again, delayed the trial. So the most important thing to the judge was to get this trial going on its April 1st start date. And probation imposed by the court not in excess of 2 years or imposed by the court or counsel with the consent of the respondent not in excess of 2 years. Or they can be reprimanded by the court or the board. A reprimand shall be in writing and either imposed in person or served upon the respondent by certified mail. A reprimand issued by the court shall be published in the official reports for the guidance or other lawyers. A reprimand imposed by the board. So this is the board. I don't know if this is the same as the judges. The sanctions that I read in Massachusetts that a judge can do are just very similarly, you can get sanctions for this, that, and the other, and very brief. So that'll give you an idea. I don't know if people will complain I think people should complain to the Bar Association of California for Alan Jackson and Elizabeth Little. Complain to the bar about David Yannetti. I think concerned citizens should. This is very concerning that all this went on in our public court in front of our eyes of the public, and the press should have been on fire with this story.
So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Ms.
So it's really about not how the Commonwealth has been heard, it's about what Karen Reed wants. And Karen Reed, I would think the way this went down is in sidebar. Karen Reed was asked that her lawyers have been found to be grossly violating the law. Do you want to stick with them? I'm sure it wasn't put that way, and that you will not be able to appeal. And this was something that Adam Lowley brought up in his filings before the first trial, that Karen Reed cannot appeal. They want it on the record that she cannot appeal, that her lawyers are acting like criminals. They can't, he didn't put it that way, but beyond, or not following the rule of law, and that she can't appeal for insufficient assistance of counsel. So I believe she was warned that she will not be able to appeal on grounds of inefficient assistance of counsel. She cannot say that she did not know that her lawyers. So let it be known that when you get caught doing something like this, it makes it look like you can't win in court by playing fairly, that your lawyers are criminal, insufficient, not representing you, following the rule of law. And Karen Reed desperately wanted to keep all of them. That should tell you something.
Mr. Jackson, lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice license.
Doesn't it look like Alan Jackson? He's just got he's got a little flushed face. Yannetti has his poker face on, his concerned poker face. He wasn't a willful participant in all of this. What they did in this case is so beyond, in the judge's findings, there's a July incident between Alan Jackson and Boston Magazine writer Gretchen Voss, where they are offering her information that they aren't allowed to give her, and asking her to not report on this information until it comes out in their filing. And this is so they would use these filings to whip up the public about conspiracies and corruption and plant information in it so that it could be reported on, in addition to using it in court. But just hold off on this. I'm going to tell you something you shouldn't know. And this is why, one of the reasons why, this is just one instance that we know of, that's public, that Gretchen Voss fought so hard to keep her unedited interview tapes with Karen Read out of the public domain. There appears to be collusion between Karen Read's lawyers and Gretchen Voss. My thought is that they went to Gretchen Voss and solicited her to write this story because it's all told from Karen Read's point of view. And she made big errors and didn't correct them.
I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word.
I need to be able to take counsel at their word. This is the public dressing down. This is the sanction.
So I'm not going to tolerate false statements, any stretching of the truth.
She's not going to tolerate false statements, any stretching of the truth.
No misleading distortions. There's no place.
No misleading distortions. What are they? All these are all euphemisms for lie, for the word lies. She could have said, stop lying to the court. I'm not going to tolerate any more lying to the court. She could have said that. But she's going to find all sorts of euphemisms for it.
For that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to...
So right after this, look what happens in the same hearing. So that morning, she just said, this is about an hour later or so, approximately. Alan Jackson gets up. She's not going to tolerate any more stretching of the truth, any more lies to the court. And they have a motion to keep out any mention of witness harassment or any, relationship between Karen Read and Aidan Carney. And they deny that there's any relationship. Now, Aidan Carney is on the Commonwealth's witness list. So I don't know how it's going to come in if the judge has to decide whether it's coming in or not. I don't know what they can ask Aidan Carney if judge says we're going to keep it out. But to show consciousness of guilt, Hank Brennan wants to bring it in, meaning he's showing that Karen Read, after committing this crime, that's his theory, my theory too, my belief and theory too, the case, after committing this crime, colluded with her and her lawyers and Aidan Turtleboy Carney to start a witness harassment campaign and a disinformation propaganda innocence fraud campaign that would terrorize the public, terrorize her detractors into silence, and put the people who had the most knowledge of Karen Read's guilt in the bullseye. Michael Proctor, Jen McCabe, et cetera, et cetera, et cetera. Karen Read says in this, I think it's one of the more damning statements she makes in this TV show, disgustingly titled, most victim-hating title in a long time, coming out of true crime, A Body in the Snow. She says, Either Jen McCabe is going down or I'm going down. Either she's going down or I'm going down. That's not a direct quote, but it's to that effect. It may have been either I'm going down or Jennifer McCabe's going down, or either Jennifer McCabe's going down or I'm going down, but that's what she said. Meaning it's her or me. So better someone innocent than someone guilty like myself going down. I'm not going down for this. I'm not going to take any responsibility for my own actions or behavior.
The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties.
Right. So they want to keep out any mention from the witnesses that they were harassed. Now, in the first trial, Alan Jackson, because he's not a very good lawyer, asked the question, why did you go to the proctors? Meet with the proctors. And that opened the door. The judge felt that he opened the door for Jennifer McCabe answering any way she wanted. And that brought in the witness harassment campaign.
Both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed.
See, this is the lawyer speak. So no one really thinks that Aiden Carney is Karen Reed's spokesman. But when Karen Reed directed Aiden Carney to go up to Jen McCabe and say, do you think you can outsmart Karen Reed? He was directed by her. That is in the affidavits to get Karen Reed's 2 phones that she communicated with Aiden Carney with. It's out in the public domain. And Hank Brennan, in his counter argument, is arguing to the judge, you know how the defense works. You know how dishonest this argument was. And watch what she does.
For the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that it did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger.
Here we go.
Named the blogger, but she said, quote, the defense is very familiar with this person, end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it in some way, shape, form, or.
So Alan Jackson, very much like his client Karen Reed, is going to take no responsibility for his own actions, for opening the door to this answer. And instead, he's going to blame Jennifer McCabe for crowbarring in her witness her harassment by Aiden Carney at the hands of Karen Reed and her lawyers. I mean, isn't it so telling that not once did Karen Reed ever say, please don't harass witnesses in this case. Support me, but don't harass witnesses. Please stop booing John O'Keefe's family. Treat them well. You can support me, but I've always found that so curious.
Fashion. She outright suggested to the jury that Miss Reed and the defense were responsible for the acts that she went on to describe in great detail, and which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden. And she.
It's Karen Reed who's bearing a burden. If other people are suffering, Karen Reed shouldn't have to bear the burden because she has no part in it. So here they are publicly saying that there is no connection between Karen Reed, her lawyers, and Aiden Turtleboy Carney. When, Hank Brennan's going to bring it up, Karen Reed herself admits that there's a connection, that they give him public information, only public information. She's very sure, she's very confident and sure to add that the only information they have given Aiden Carney is public information, already made public. We haven't, it's almost like an admission if you really listen closely. There's no need for her to say we only follow the letter of the law, because there should be an assumption that her and her lawyers are following the letter of the law. But we're only given public information. It's not like what we did with Gretchen Voss, give Aiden Carney information that isn't public. And I believe, and ask him to report on it, or get a jump start like we did with Gretchen Voss. So start reporting on this, so by the time it's public, you can get it out right away and create a big media sensation with it. That's what they wanted.
Did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down, and which also happened. It serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear.
Right. So he's saying it's galling. He's accusing the Commonwealth of galling behavior by knowing that Karen Reed wasn't indicted by the grand jury for witness harassment. Now, we don't know what evidence was presented to the grand jury. We don't know why they didn't indict her. Could it be that they also, at the height of the Free Karen Reed movement, did they worry about, this is what the question I have to ask, any kind of retaliation and disturbance in their life had they indicted Karen Reed on witness harassment? Had some of the grand jury been already soaked in the innocence fraud, Karen Reed's innocence fraud campaign. But we don't know why the grand jury chose to not indict her. But that is not Karen Reed and her lawyers and Aidan Carney, et cetera, will all say that that's proof that she's not involved with Aidan Carney, but her own words betray that decision. That she was involved with the witness harassment campaign. There are many calls, tens of calls between Alan Jackson and Aidan Turtleboy Carney and David Yannetti and Aidan Turtleboy Carney during the time that witnesses were being harassed. And this is the first time that they've ever publicly disparaged the witness harassment campaign. Isn't it awfully convenient?
Your evidence on whether or not Miss Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill.
So here again is Alan Jackson making the same argument that Aidan Turtleboy Carney made, that a grand jury will indict a ham sandwich, but they won't indict Karen Reed for witness harassment. Thus means there's no collusion. There's not a symbiotic relationship between Aidan Turtleboy and Karen Reed. I don't think it's really proof of that at all. We don't know why they did it. There are many reasons, and without talking to the grand jury and without seeing the evidence presented to the grand jury, I think that is a jump in a conclusion. That means that she wasn't involved.
And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Miss Reed.
When was that no bill issued?
You said when or where?
When?
I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Issue, the court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to this Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about.
Well, when you ask a why did you do something question, Jennifer McCabe can answer any way she wants, including why she met with the Proctors was due to the witness harassment campaign, if she felt they were connected. That's how you open the door. And that's why you don't hear all that often lawyers asking, why did you do, this, that, and the other if they want certain piece of information out. They ask yes and no questions. They ask questions in the form of, so, that really are answers, kind of, you know what I mean? So you did that because you wanted, isn't it true that you did this because of that? And they can answer yes or no. But he did open the door.
And sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense, for all intents and purposes, about things that are completely out of our control.
Isn't that interesting that the defense doesn't want a free-for-all, doesn't want to be lambasted by things that are out of their control? Like becoming a witness in a case? Isn't that kind of out of your control? And being lambasted for it? We want to harass all the witnesses we want, but we don't want our side to be affected by it.
Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to.
Heisenberg, thanks so much. He says, in the new interview, Roberta, she says something that will work against her. She confirmed that her car sensors were working. Good gold for Hank to use. The car data is so damning, and the infotainment system, the fact that she had an infotainment system that would beep, flash. I mean, the beep is like a very unnatural, loud alarm that goes off when you're about to hit something, and it gets louder and louder and more intense in intervals the closer you get to hitting something. Also in these interviews, it's very damning. She says that she couldn't hear because of the stereo and the wind and I think that's the reason why she brings up the howling wind and the stereo, and she would have missed hitting something. It goes through, anybody who's ever hit something in a car knows it goes through the car, through your whole body. You can't not feel it. But she says, well, when I'm drinking, I don't remember as well, but I remembered everything from that night. The fact that Karen Reed wants to use alcohol the way she's used it and use jealousy the way she's used it will show you, or it shows me at least, that this is not a crime about jealousy. It's not a crime about alcohol. This is a crime about power and control. And whatever John O'Keefe did, whether it is, in my view, it's saying enough, this is over between us, or some other offense to Karen Reed was going to teach John a lesson, was going to show him. She was going to play God and punish him. And when she backed into him purposely at 24 miles an hour, she meant to cause him serious injury or death. My feeling is death, or she would have gone back. I don't believe she slept that night. Thanks, Laxy for gifting 5 memberships. My understanding is they'll be handed out in random. Tomorrow morning, by the way, is a hearing. And after this show, I'm going to be on Kick, and I'm just going to play the last hour episode of the TV show A Body in the Snow, The Trials of Karen Reed. But listen to Hank Brennan. Hank Brennan has had enough. Here's his answer to, again, here's the judge saying she's not going to handle any more lack of candor in the court, misstatements to the court, stretching of truth to the court. Those are all euphemisms for lying to the court. Alan Jackson, because he's not a very good lawyer. And he's essentially, that's in my view. This is my view, not a fact. My view, he is, likes to get over on the court. He likes cheating to win. He's going to lie to the court because they can't win this motion to keep this stuff out by saying the truth. Well, we do have a relationship. Well, yes, we were behind the witness harassment campaign, but we don't want it to prejudice our client without losing, I would think, some public support for Karen Reed.
To identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Miss Reed talked about speaking frequently to Mr. Carney.
And I wouldn't even call it a documentary. I call it a TV show. Documentary has some aim to actually document what has happened and not craft it for the maximum drama and maximum appeal to both sides of the issue of Karen Reed. Certainly the first 2 issues seemed like they were for the non-supporters. These last 2 were for the supporters. And it made the trial, by editing the trial, gave a distorted view of the trial and a distorted view of the success of the defense, I thought. When you watched the whole trial, the defense seemed very ineffective.
Sharing anything public with him. And you would have to choose to be oblivious to think that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand.
See, there he goes. He calls it fraud. Fraudulent argument. And he's like, Judge, are you going to do something? You just said you're not going to tolerate this in your courtroom. And here you are tolerating it again. And it not only is he insulting the the entire United States of America by violating our laws and making our courts look like a kangaroo court by so flagrantly breaking the law and going beyond the rules of his profession, breaking the rules of his profession and acting like a criminal. He's also making a fool of the judge. What are you going to do? I'm going to do it again. What are you going to do? You know you want this trial to start April 1st. What are you going to do again? You can't throw me off.
The purpose of that, when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside.
All right, let me catch up with these comments. So Heisenberg says, let's also mention, she also told her father, this is Heisenberg's excellent point, that she felt she struck something. That is a experiential memory, is I think what Heisenberg's saying here. When you feel you hit something, you feel it go through your whole body. That word felt is not picked out at random. We choose words for reasons. 2 point of contact, and she didn't even step out to check what that was. Right. When have you ever hit something and didn't step out to check? And then he corrects something and thought she hit something. Felt she hit something and thought she hit something very different. Thank you, Lackadaisical, for very generous 20 memberships, which will be given out they're given out at random in the chat. So you have to be in the chat when someone like Lackadaisical is generous enough to gift memberships. Be in the chat, be chatting, and you could be randomly given one.
Patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really...
He's like, we don't want this to come in. We agree that it's prejudicial. But when you open the door and when it comes in, we'll be prepared. So once it's coming in, we're going to be prepared. And is that the time that Aidan Carney is going to be called as a witness? Sure love to know what he's going to say under oath, don't you? Under penalty of perjury. Being asked questions that they know the answer to, these lawyers that would not ask questions that they don't have proof of. It's going to be pretty fascinating trial. All starting April 1st. I can't wait. I know. I don't know about you.
And an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
So I'll spare you, Alan Jackson, getting up and saying, how dare the Commonwealth accuse me of fraud. Does everybody remember this part? He gets up in arms, rants and raves about what he's done. Yeah, thanks, Snow Remover, for being a member for 2 months. It's so wasting time and money on federal appeals. I agree, but it's not her money. So a friend of mine pointed out. She's just getting endless cash from her supporters for her lawyers. They've raised $750,000, maybe more, for her. It seems to be an endless well of people who are willing to give their hard-earned money to support someone accused of such a heinous crime. Ditto Luigi Mangione in New York just got $30,000 donation to his GoFundMe. It's in the $100,000s, and a $36,000 donation. These innocence fraud campaigns are lucrative. There is always someone in the public willing to give money to support someone accused of something heinous. She just raised, is that drop of Jupiter, $23,000 on St. Patty's Day? Is that Karen Reed she raised? Yeah, so it's not her money. So she might as well roll the dice. She doesn't have a chance of winning that, of appealing that federal, the Supreme Court decision. But okay, go ahead. That means that she's trying to appeal the decision that said that she should be acquitted of the biggest charges against her because the jury agreed that she was innocent of those charges and just couldn't figure out how to fill out the forms, which I have trouble believing.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness.
I mean, again, I mean, that's obviously everyone's perception. But when you say the witness wanted to crowbar in her own, making her look like a crybaby, essentially, Jen McCabe, I think that is attacking a witness. And they call them earlier in this. I could have used that as an example too. I unfortunately had to keep it short. Elizabeth Little, again. So what the decision was for the defense is that they could not mention a third-party culprit. So meaning that someone else did this crime other than Karen Reed. They couldn't name them, say that someone else did this besides Karen Reed, unless they developed it in cross-examination. And then David Yannetti, in his opening, said, Karen Reed's been framed. Someone else did this. He didn't name them specifically, and nothing happened to them. And in this hearing, so they never developed the third party culprit through the entire hearing, trial, excuse me. And then in this hearing, Elizabeth Little comes in and describes Jennifer McCabe, Brian Higgins as third party culprits. They've never developed that in any cross-examination, in any lawyering done in the court, because they can't, because there's no evidence of them being third-party culprits. Again, a stretching of the truth. A deliberate lie upon the court. And what was done about it? Nothing. This is the conspiracy. Why isn't the press writing about this? Why am I the only person talking about this conspiracy? And Heisenberg says she even laughed at Allie McCabe on the stand. The judge rules very loosely over her court, the behavior. Like I said, I've been in court, in New York federal court, the Nexium hearing, and a reporter was thrown out for giving a look by that judge. He was not going to put up with any nonsense. This puts Karen Reed, the fact that there is inaction when there's such a gross violation, we'll see what happens tomorrow, or you can also see what happens after the trial. Is the judge waiting till after the trial to sanction them? I would doubt it, but let's see. We'll see tomorrow morning, 9 o'clock. I believe it starts at 9. I'll be live streaming. But he just rants and raves about how unfair it is and what the gall of just very shortly. I just wanted to show you, just had a few things to say about this. This was sent to me. This is from Julie Grant's show. John DePietro's the guest. They're talking about how there's been a change in the defense. Certainly, I agree that the defense, it's not the same defense. It's kind of a wacky copy, but okay. This is not the same defense that we've seen. They're not as confident. They're not as polished looking. But here they're talking about how the judge is talking to the defense and how the judge is more skeptical. And I have a few comments to make.
Appreciate you bringing that up because that has been somewhat of a fallback argument, somewhat of an argument that just keeps, being forwarded, on social media. Oh, but the feds are investigating. It's important to remember, and I know you know this, it was Karen Reed and David Yannetti who initiated this. They went to Joshua Levy and said, you ought to look into this. And it found nothing, no evidence of corruption, no evidence of anything wrong with any of these innocent witnesses who have been tortured.
Manny's asking, why don't they sue for defamation? Well, it's because it's expensive, for one. It's time-consuming. It's stressful. And Karen Reed may say she's totally destitute. So then you spend a whole lot of money doing nothing. There's not a lot of reward in it. We may see civil actions after Karen Reed's trial. She's already sold her home. I don't know what assets she has left publicly. She's very crafty. I would assume she's hid them in different ways. That's what I would assume.
Hank Brennan, as we've talked about before, has exposed that relationship between Karen Reed and Turtle Boy. What's good for the goose is good for the gander. Tell me, did you think yesterday, I know there was a moment with Judge Cannoni and Alan Jackson that got pretty heated. We may have that clip. Did you sense some annoyance? Is there a different a different Judge Cannoni, maybe the way she's talking with Alan Jackson from what we saw in the first trial?
I'm glad you mentioned that, Julie, and picked up on it. 100% yes. She is questioning every word. Alan Jackson is off balance. He's not the Alan Jackson.
What? She's questioning every word. We just watched him give a completely fraudulent argument of which she questioned nothing. What is this nonsense? What is this nonsense? What is this gaslighting?
I'll say one thing. I sat there last spring. He owned the courtroom, and not just inside, outside the courtroom. That dynamic is gone. I find Judge Cannoni is questioning every single word that he says. She questions them. She's very aggressive in her questioning of him in specific words. Yesterday was so dramatic as Hank Brennan and Alan Jackson, two very skilled attorneys, battling it out. But I would say right now, a huge difference.
What was the questioning? What questioning? When she said, you open the door, you should read the transcript, I did. That was the intense back and forth? After he made his lying argument to her? I think what they're talking about here, and that's all that I'm going to share, he goes on to say that Hank Brennan and Alan Jackson are two great lawyers. I disagree. I think one good lawyer and one terrible criminal lawyer going at it. Certainly, they're both polished performers. That can be misconstrued for great lawyering, but I wouldn't call Alan Jackson a great lawyer. I just think it should be brought up on the positive note. I think what they're picking up on is that the defense team, Karen Reed's at the end now. Doesn't mean she won't get acquitted. Doesn't mean that we won't see another hung jury in this case. Certainly innocence fraud campaigns are powerful. And their effect lives on long after the case. They affect other cases in the future, how they're done. But I think we're seeing the end for Karen Reed here. ARCA was the best thing she had in her defense. That is gone. Everything else, she can put up 50 witnesses. They're still being paid for by the defense. They're still hired guns by the defense. And you can't change the truth. So they're at the end. Everyone seems to realize it out their defense team. They're out of tricks. They're out of gas. Who knows? They may have new tricks up their sleeve. We'll see. But for the tricks that they have all been exposed by the Commonwealth. A lot of these things were brought up in filings by Adam Lally and ignored by the public. But so I think that's it for Karen Reed. I think a conviction of something, it may be a smaller, lesser charge. It may be second degree, but my money is on her being convicted of something. That's the momentum now. I'd like her to see her convicted of everything. I don't know if that's possible with this judge in Massachusetts, but let's see. But the momentum is definitely in the Commonwealth's favor now. And certainly her public campaign seems to be winding down. Let's see if it's hyped up by this new TV show. Could be. I'll see you all tomorrow morning. I'll see you now on Kick. I'm going over to Kick just to stream the latest. See you there. Have a great night, everybody. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system, my clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John, you were my mark. My innocence fraud campaign is my biggest hit yet.